we will be covering today is the Target data breach that occurred in 2013. Group members include Brandy Aronson, Kelsey Rankin, Caitlin Snelling, and Erica Allen. For the case regarding the Target data breach in 2013, we will cover the following topics: the facts that gave rise to the legal issues, the summary of the legal issue, an analysis of the law, the application of the law to the facts, the outcome of the legal issue, and recommendations that we would give to guide the company to avoid similar legal issues in the future. First, we will cover the facts that gave rise to the legal issues. Between mid-November 2013 and December 15, 2013, over the holiday shopping season, the largest data breach in history took place at one of the largest national retail stores, Target. Target's point-of-sale systems were hacked, and over the course of the following weeks, the hackers were able to fraudulently secure the personal and financial information of an estimated 110 million Target shoppers. According to Reuters.com, information obtained by investigative journalists, security experts, government investigators, and by members of the U.S. Senate in hearings shows the data breach easily could have been prevented as Target failed to take adequate and reasonable measures to ensure its data systems were protected. They ignored clear warnings that intruders had breached its systems and failed to take actions that could have thwarted the breach. Because of Target's numerous and preventable failures, plaintiffs reportedly suffered millions of dollars in damages. Numerous class action lawsuits were brought up against Target for their negligence and failure to protect consumers' personal and financial information. Next is the final class action lawsuit count against Target for the data breach ended at 140, all of which were overseen by U.S. District Judge Paul Magnuson. The court separated these lawsuits into categories of class action lawsuits. The categories consisted of the consumer lawsuit and the bank lawsuit. For the consumer lawsuit is known as the Target Corporation Customer Data Security Breach Litigation, number 14-2522. The summary of the legal issue is as follows. Plaintiffs claim that Target was negligent and that Target did not adequately protect their payment card data and personal information, and that Target delayed in providing notice of the data breach. The plaintiffs listed injuries including unauthorized charges, personal information theft, financial information theft, reimbursements for purchases made during the time of the breach, loss of time that went into dealing with the outcome of the data breach, cost and losses associated with the data breach such as fees, late payments, and any damage to their credit standing. Once the lawsuit was filed, Target quickly filed a motion to dismiss. Target argued that the plaintiffs did not allege a present injury sufficient enough to warrant case or controversy standing under Article 3 of the Constitution. Judge Magnuson denied this motion and explained that the plaintiffs demonstrated injuries and granted the class action lawsuit. The bank lawsuit. The banks involved in the class action lawsuit included CSE Federal Credit Union, First Federal Savings of Lorraine, Mutual Bank, Umpqua Bank, and Village Bank. These banks pursued a class action lawsuit. This lawsuit would be on behalf of all banks that were affected by the data breach. The plaintiffs listed under the summary of action that in late 2013, the sensitive financial and personal data of approximately 110 million shoppers was compromised as a result of Target's failure to adequately secure payment information on its systems. It was one of the largest data security breaches in United States history, yet Target's security protocols were so deficient that the breach continued for nearly 3 weeks while Target failed to even detect it. In addition, the financial institutions that issued the debit and credit cards involved in Target's data breach have suffered substantial losses as a result of Target's failure to adequately protect its sensitive payment data. Damages and injuries listed included costs of notifying customers, reissuing cards, reimbursement of fraudulent transactions, monitoring accounts, addressing complaints, and changing and suspending accounts. Again, Target quickly filed a motion to dismiss. Target asserted that the case should be thrown out because the retailer has no direct contractual business relationship with the financial institutions. Judge Magnuson again denied the motion to dismiss, stating there was sufficient factual allegations to proceed.
Thank you, Brandy. We will now begin to cover the analysis of the law. In the eyes of the law, Target's data breach was caused by pure negligence. The four main elements that a plaintiff needs to prove an action was caused by negligence are duty, breach, causation, and damages. In this case, the plaintiffs claimed that Target had a duty to protect their consumers' data from hackers, to not disable security devices, and to respond when alerted to an attack. Target argued that they do not have a duty to protect the plaintiffs, since this data breach resulted from a third party's criminal act to another third party. Target's reasoning behind this was that Target and the plaintiffs did not have a special relationship. If they had, Target would then have a general duty to protect them. Overall, the court sided with the plaintiffs that Target did in fact have a duty for not just special relationships, but to provide data security measures for all relationships within their company. In order for Target to prove there was not a breach of duty, they would have had to use the Hand formula created by Judge Learned Hand. The Hand formula is where one has to prove the burden of taking precautions is less than the probability of injury multiplied by the gravity of any resulting injury. In this case, Target would have had to prove that the burden of precautions they took to secure the plaintiff's data was greater than the probability of loss multiplied by the gravity of the resulting loss. Target was not able to prove that the precautions they took to secure the plaintiff's data was greater than the overall loss that those plaintiffs faced. Once the overall decision that Target was liable for the breach of duty, the court implemented 3 new duties to all companies, especially Target, when it comes to data breaches. Those 3 duties are: 1. A duty to safeguard the company's and the business's associates' consumers' data. 2. A duty to not disable security features that will prevent data breaches. And 3. A duty to notice the warning signs of an attack and respond to the attack appropriately. With these 3 new duties implemented, if Target or another company decides they do not want to comply with the duties, they will automatically be charged for negligence, resulting in them having to pay and cover all costs of appropriate damage the plaintiffs have faced.
In this case, millions of people were affected by Target's data breach of their personal information. There are state laws in place to protect people and alert them about hacker crimes, such as the State Data Breach Notification Law. This law varies depending on the different states. There are no federal laws requiring the disclosure of security breaches. Since there were multiple states that filed a lawsuit against Target, Target decided to offer 1 year of free credit monitoring to all customers per the state attorneys general. During this case, Target was fully aware of the laws protecting the data and the need to secure sensitive personal information. However, they were negligent by not having their data fully protected, and this was part of their duty to their customers by law.
Now we will discuss the outcome of the legal issue. From the class action lawsuit, Target provided a large settlement to consumers, banks, credit unions, MasterCard, and even the states involved in the investigation. For the 41 million affected consumers, Target paid $18.5 million in the multi-state settlement. This was to compensate for the cyber attackers gaining access to credit card, customer information, and other sensitive information through malware. This class action lawsuit helps set the standard of how companies should handle consumer information. Along with the payout, Target also agreed to pay up to $10,000 to consumers with evidence that they suffered losses from the data breach. The banks and credit unions were given a settlement of $20.25 million. Target also reached a settlement with MasterCard for $19.1 million, but MasterCard deemed the amount too low. Ultimately, the settlement won preliminary approval from U.S. District Judge Paul Magnuson in St. Paul, Minnesota, who called it fair, reasonable, and adequate. The states involved also received a settlement through shares of the Target payments. This money went to cover attorney fees, investigation costs, protection law enforcement funds, consumer education, or other purposes. These funds allowed for the states to recoup their losses and continue their work to protect consumers from any future breach. Outside of the settlement, Target quickly implemented new policies, processes, positions, and protections for the consumers. These included the development, implementation, and maintaining of a comprehensive information security program, hiring an executive or officer responsible for executing the information security program, hiring an independent expert to conduct a security assessment of the company, maintain data security software for the company's network, separate the cardholder data from the rest of the network, take the necessary steps to control network access. That includes password rotations policies and two-factor authentication. They disabled, reset, and reduced privileges for over 445,000 Target personnel and contractor accounts. And they also were implementing POS management tools and installed an application whitelisting POS systems. Target made sure to quickly place these on their website so that they could reassure consumers that their information was safe when choosing to shop with Target.
In the future, Target should always have a secure, strong, and reliable information security system in place for all their customer data. This includes implementing, maintaining, and supporting their data systems that contain any company or customer information. Also, they need to take the necessary steps to ensure they hire or seek professionals to continuously evaluate their data security procedures. To avoid a similar issue, they should make sure their customers' credit card information is stored separately from all other data with max security. Overall, Target needs to put forth more resources in their data security department to not only protect their company, but to protect their customers.